In this video, we're diving into Section 19, Joint Escrow Instructions to Escrow Holder, one of the most important, but often overlooked, parts of the contract. This section explains 1. How the RPA becomes the official roadmap for escrow. 2. Identifies which contract paragraphs escrow must follow. 3. Explains how escrow handles funds, documents, and commissions. 4. Breaks down how escrow receives instructions from both parties. 5. Clarifies escrow's responsibilities during the transaction. 6. Details how broker compensation is paid through escrow. 7. Covers procedures for deposits, invoices, and tax withholding requirements. By the end of this video, you'll understand how escrow uses the RPA to coordinate closing, protect both parties, and ensure the transaction complies with state and federal law. Let's get started. Section 19A, Escrow Instruction Paragraphs. 1. The RPA lists specific paragraphs that you see in Section A that are escrow instructions. 2. Those paragraphs tell escrow how to close, price, deposits, credits, payoffs, title and fee instructions, prorations, etc. 3. Other paragraphs of the contract are for information only. Escrow doesn't have to police or enforce them, for example, how showings are handled. Escrow doesn't enforce the entire RPA. It only follows the specific sections that give escrow type instructions. Everything else is between buyer, seller, and the brokers. Section 19B, Escrow Holder General Provisions. Most escrow companies have their own general provisions packet. 1. Buyer and seller agree escrow may use its standard general provisions in addition to the RPA. 2. If those provisions conflict with the RPA controls. 3. Buyer and seller must sign and return any additional escrow instructions within the time set in Section 3N2. Always read escrow's general provisions. If you see a conflict with the RPA or your addenda, talk to escrow and your broker immediately. By default, the RPA wins. Section 19C, Copies, Statement of Information, Tax Withholding 1. Copy of the agreement to escrow, a copy of the fully executed RPA and any counteroffers/addenda must be delivered to escrow within 3 days after acceptance. Buyer and seller authorize escrow to rely on electronic signatures as originals. 2. Statement of Information. Escrow will request a Statement of Information, SI, from seller and often buyer. Within 3 days, escrow must provide seller's SI to the title company, so title can clear name issues, liens, judgments, etc. 3. Tax withholding, FIRPTA/state. Escrow will also handle withholding instructions, FIRPTA, California withholding, or other tax requirements. If seller gives escrow an affidavit that no withholding is required, escrow follows that. Otherwise, escrow withholds and reports as required by law. Escrow is the hub. They get the signed contract, statements of information, and tax forms so title and withholding can be handled correctly. Section 19D, Broker Compensation. Section 19D1, Payment. 1. Escrow is not a party to the RPA, except for handling commission payments. 2. Escrow will follow separate written compensation agreements, listing agreement, buyer-broker agreement, or special instruction regarding who pays the commission, seller, buyer, or both, and how much is owed. 3. Buyer and seller authorize escrow to disperse commission to the brokers at COE, or per written cancellation agreement, consistent with paragraph 18A. 4. Those instructions can be changed only by a written, signed amendment from the parties and brokers. Section 19D2, Compensation Disclosure. 1. Escrow will provide written disclosure, often on the closing statement, showing the amount of compensation paid to buyer's broker and the amount of compensation paid to seller's broker and by whom. 2. This keeps everyone transparent on who is getting paid what at closing. Commissions are not secret. Section 19D tells escrow exactly how to pay brokers and requires that compensation be clearly shown on the closing statement. Section 19E, Invoices. Buyer and seller acknowledge escrow may require invoices for costs tied to the transaction, HOA docs, home warranty, termite, recording, etc. If escrow asks, buyer or seller must deposit funds to cover those invoices within a reasonable time, often 3 days, so escrow isn't stuck unpaid. Section 19F. Verification of deposit. 1. When escrow receives buyer's initial or increased earnest money deposit, escrow will let the appropriate agents know that the deposit has been received and confirm whether it was by check, wire, or other form. 2. If escrow becomes aware that buyer's deposit bounced or was never made, escrow notifies the agents. Then, buyer may be in breach under the deposit paragraphs, and seller may use a notice to buyer to perform and, if unresolved, cancel. Escrow is the official referee on whether the deposit is really there. If a check bounces, escrow tells the agents, "That's not something we hide." Section 19G. Delivery of funds. 1. Buyer and seller instruct escrow to release and disperse funds only when the contract conditions for those funds have been met, for example, at COE for the sale proceeds. 2. Funds must usually be in the form of good funds, typically wire or cashier's check, by the deadline escrow requires to record and close on time. 3. This protects both sides from funds being given out too early or from uncleared checks.